Hi, y'all, and welcome to tonight's live stream. It was a twisted, dark, and devastating case to begin with. Richard Allen is accused of murdering two young teens, Abby Williams and Libby German, who were doing nothing other than going for a walk on an unseasonably warm day in February 2017. But usually, these sorts of cases straighten out in the legal system. Dark facts become written charges, and then appalling facts become just clinical elements of a crime. You have terrifying truths that just become examination, testimony, cross examination. And so the Byzantine gets kind of straightened out in the legal system, but not in this case. Now, the attorneys and the judge in the Delphi murders case are in a pitched battle in the Indiana Supreme Court. And today we're going to unpack that battle. I want to say thank you to everybody. I hit 125,000 subscribers this week, the week of Thanksgiving, which couldn't be any more appropriate. I'm so thankful for all of you who watch and subscribe. Thank you immensely. And if you haven't joined us yet, well, what are you waiting for? We'd love to have you. Please subscribe. Come back. We do live Monday, Wednesday, and Friday at 7 p.m. So hop on in. Now let's dive into what may be the strangest case in America. And I say that with some background because after all, we've covered Murdaugh. We've covered the Lori Vallow Daybell case. So I'm not saying this casually. Let me give you a 1-minute explanation of the Delphi murders case, not a detailed explanation. We've got plenty of other videos on that. But for those who are new to it, as I mentioned, the two teenage girls were taking an after-school walk together. They were missing overnight. They were found. They have been stabbed to death. Richard Allen is now accused of murdering these two young teens. Now, the defense says he didn't do it. You got the wrong guy. They say this crime was committed by oedness. Oedness, you say? Well, the defense explains this is a pagan religion, which in the U.S. has sort of morphed in the prison system into a white supremacy group. And that's who killed these two young girls. That's what the defense says. That's what Richard Allen's lawyers say. And their evidence of that, we covered that in great detail, was that, among other things, that the crime scene was very ritualistically staged, they say, that the bodies were arranged and there were sticks placed on them in symbolic fashion. And there was even a nearby tree marked with a symbol called a rune, written in blood. It was, without question, a bizarre case already, but the attorneys filed a 126-page motion with wild allegations and facts in it. They marshaled huge amounts of evidence. They unveiled a lot of new evidence that the public did not know up until then, such as the markings on the tree or the way the bodies were arranged. From my perspective, personally, I thought it was a remarkable piece of work because I could tell how much work went into it. I mean, it was an extraordinary amount of work to marshal all of that. The public, ever since he was arrested, has assumed he did it. After all, he was arrested, right? So he must have done it. I think the attorneys at least managed to introduce the idea to the public that maybe Richard Allen is the wrong guy. So the public narrative has all been against him since he's been arrested, but the attorneys did something to try to turn the ship around. Sort of picture it this way, like a ship being pushed through a strait in rushing water. It's being pushed through. The idea of trying to turn that around is not easy, but the attorneys made an effort, and I really admired that. I admired that they did that and did it with an extraordinary amount of work to give their client a chance where there was no chance before. And it was quite dramatic. But then, drama on top of drama, a leak occurred. Crime scene photographs were sent out. These were apparently actual photographs of the crime scene, apparently of the bodies of the young girls. Now, that's really sick stuff and normally would not be made public. It's so painful to the families to have something like that made public, and it's frankly nobody's business. The jury will be forced to see it. That's because the jury has to know the information. The jury has to know what exactly happened in order to make a correct decision about Richard Allen. But normally, the public wouldn't see those very intimate photographs because they are so graphic and so difficult for the families, because it would be so difficult. Now, here's the path as I understand it. It started out with M, just the initial, that's all. And I can't even tell you, was that the first or last name? But M sent the photographs to R, also only an initial. R sent them to Mark, and Mark sent them to the Murder Sheet podcast. We had Anya and Kevin on our show a few months ago, a couple of months ago maybe, and the photographs were sent to them. And that's when all hell broke loose from there. Within a week or weeks, R departed the earth in a way that cannot be named on YouTube. The Murder Sheet reported to law enforcement what had happened within, as I understand it, about 24 hours of the time that they received these photographs, and also traced these photographs back through to M. It turns out M used to work for one of the attorneys representing Richard Allen, for one of the defense attorneys, Andrew Baldwin. Now, Baldwin's brief suggests that M visited, I don't know all the details, I'm just sort of guessing from what little is said in the briefing, that M visited, the photos were on a table in a conference room. M went in and I assume took photographs and then sent them to R, as I said, and then R to Mark, and Mark to the Murder Sheet podcast. And there may well have been other people who received them too. I don't know. Now, next, there was word that law enforcement was investigating this leak. Then a few weeks later, there was supposed to be a hearing. And instead, I'm going to show you, this is what happened.
Patience, ladies and gentlemen. Thank you, Mr. McClellan, Mr. Luttrell, for your patience. We've had an unexpected turn of events, ladies and gentlemen. Earlier this afternoon, the defense attorneys have withdrawn their representation of Mr. Allen. Mr. Baldwin made an oral motion to withdraw. I granted that oral motion to withdraw, and Mr. Rosie will be submitting a written motion to withdraw, I'm assuming within the next couple of days. They have confirmed with the court that Mr. Allen's financial situation remains static, meaning he is continuing to be entitled to appointed counsel. I will reach out to public defenders to make that appointment. As Mr. Allen is now without counsel, I've ordered him transported back to the Department of Correction. Mr. McClellan, I know that we have already scheduled a hearing in the Carroll Circuit Court October 31st at 9 a.m. I'd like to maintain that hearing if we can, please. I think at that point we can have counsel appointed. I'd like to set a new trial date. Obviously, I don't believe counsel will be prepared within the next couple of months to try a case of this magnitude in January. So we'll set dates for the trial. I think we need to set a date as well for the suppression hearing that was filed now by former counsel. Thank you for your patience.
So, an absolute shocker. Attorneys who had filed this 126-page brief, put it on their website, made sure that the world knew all of these facts about their client, just suddenly resigned from the case. Are you kidding? That was so improbable, because they weren't just partly in the case. They weren't just, hey, I'm representing him, what's the next motion I need to file representing him? They were all in. They were fully invested in the case. They were filing motions. They were doing way more than was absolutely required, and almost certainly more than they were going to be paid to do. And then suddenly they just resign. I wrote on Twitter something like, what is this absolutely necessary? And by the way, follow me over on Twitter at Lawyer Lee W. I comment often on cases that we don't have time to get to during the lives. So anyway, be sure to follow me over there. I mean, you can think all day long that Richard Allen is guilty, that you think that he should be found guilty, but the work that it took for these attorneys to file this brief, to put it all together, and they're working in a case where everybody assumes that they are defending a guilty guy. They get a lot of hate just because they are representing Richard Allen. And they are not going to be paid 100% as they would for a private client. It shows a real commitment to the client, which I admire. I immediately assumed that they must not have been given very much choice in this, that this resignation must have been something else going on. I thought at the time maybe they were told they were being investigated about this leak, and maybe there was some allegation that they had intentionally leaked documents, but that does not appear to be the case based on the documents that we now have available. So, but it just snowballed from there. Ever since then, we've been trying to unravel what on earth happened. The defense lawyers tried to get back in the case. One lawyer said, "Hey, I've never filed a written resignation and I'm not going to." And the other lawyer came in and said, "Well, I'd like to undo my resignation too." And the judge removed those pleadings and said, "Hey, you aren't representing anybody in this case. You don't have the right to file pleadings in this case." And on top of that, the judge appointed new lawyers. That's when the Richard Allen team went with the nuclear option. And I keep telling you this is nuclear war, but you may not believe me now that we have 3 cases where the attorneys have tried to recuse the judge: the Brooks Hout case, the Murdoch case, and now the Delphi murders Richard Allen case. But the attorneys moved to remove Judge Gull from the case, asked to have her removed, kicked off the case. And that was when we started to learn about what had happened. Now, tomorrow, or hopefully tomorrow, I'm going to be putting out a video where I'm going to read that transcript. So, and I'll explain to you, we didn't initially get the transcript, but I'll read it to you, that transcript of that private conversation back in chambers. So let me put up on the screen. This is the brief in support of the petition for writ of mandamus that was filed by Richard Allen's attorneys. This is where they're asking the Supreme Court of Indiana to remove Judge Gull. So that's what's happening. But a week later, Rick threw himself at the mercy of the court. This is talking about when there were first counsel, when they first got when Richard Allen was first given counsel. He initially said, "I'm going to hire my own lawyer." And shortly a week later said, "Oh, wait, we don't have enough money for that. That's crazy," and requested a public defender. That's when Andrew Baldwin and Brad Rosie, the attorneys, were with, they say, a combined 50 years of experience, were appointed. Over the next year, attorneys Baldwin and Rosie zealously advocated on Rick's behalf. They appropriately asserted Rick's innocence after the public release of the probable cause affidavit. They repeatedly requested a change in the conditions of his confinement due to the obvious effects the conditions were having on his physical and mental health. And they prepared a trial strategy with Rick after pouring through thousands of pages of discovery to prepare his defense for a January 2024 trial, because right now we should be just 2 months away from the trial. It was set for this coming January, the trial for Richard Allen. Yet, less than 3 months before trial, the court removed attorneys Baldwin and Rosie as counsel, citing its extrajudicial finding that counsel had engaged in gross negligence. At Rick's direction, attorneys Baldwin and Rosie entered appearances as private counsel agreeing to continue representing him for free. Wow. I mean, wow. They agreed to, this is so, I can't tell you how hard this case is, how much work it takes, how much hate they get, how little praise or glory or fame or anything positive they get out of it. And they were willing to continue representing him for free. That really says something. But at a hearing held on October 31st, 2023, the court told Rick that it had grave concerns about his defense team, that he was entitled to a vigorous defense, and that the court cannot and will not allow these attorneys to represent you. Very strong words. Cannot, will not allow them. Grave concerns about them. Rick's trial has been reset for a year from now, and he has been forced to start over with new attorneys. The court's statements about Rick's counsel have completely undermined the credibility of Rick's proffered defense. So the attorneys are saying they're worried not just about their reputations or about the effects on their client, but that the fact that the judge came out and threw them out suggests to the public that this argument they were making about the odious and about the other people who could have been responsible for the murders, that all of that undermines his ability to freely and fairly mount this defense that he'd like to mount because he believes somebody else committed the crime. After sending Rick to the DOC, Department of Corrections, the judge recused himself. The Honorable Francis C. Gull accepted an appointment as special judge. So this is just explaining how Judge Gull came to be on the case, because she was not initially the judge on the case. And then they talk a little bit about their qualifications, that Attorney Baldwin is one of only 4 Indiana attorneys certified as a criminal trial specialist by the National Board of Trial Advocacy, as authorized under Indiana rule. He has nearly 30 years of criminal trial experience, handling hundreds of jury trials and representing numerous defendants charged with murder. Attorney Baldwin has never been disciplined or suspended. Attorney Rosie has over 20 years of criminal trial experience, handling thousands of cases, including 8 murder cases. Attorney Rosie practices regularly in Carroll County and surrounding counties. He was born and raised in adjoining Cass County and is intimately familiar with the police officers and prosecutors investigating and prosecuting this case. Attorney Rosie has never been disciplined or suspended. Rick wants this partnership to handle his defense. So their argument is, we are highly qualified, and moreover, the client wants us to represent him. But the relationship with the judge certainly has deteriorated. We'll keep reading. Thank you, Marlon. I appreciate that. Let me put your on the screen. Yes, I want to say love to our viewers who can't join the live. I agree with Marlon, but thank you for watching as it gets uploaded afterwards. On November 29th, 2022, the charging information and probable cause affidavit in Rick's case were made available to the public. Attorneys Baldwin and Rosie issued a press release which responded to the allegations contained in the affidavit, reasserted Rick's innocence, and indicated they would continue to share exculpatory information with the public to the extent they were ethically permitted to do so. Later that day, the court entered a gag order prohibiting the parties from making extrajudicial statements about the case, which was reaffirmed after a hearing. The court also entered a protective order prohibiting the parties from divulging or granting access to the discovery material to all but certain people. And so what they're saying so far is that initially there was a press release made by Richard Allen's attorneys. There was nothing to prevent them from doing that. There was no order. Nothing had created a reason for them not to do that. And so they did that. I personally think that's actually commendable. I think it's commendable because I do believe that it's unfair that the state comes out, gets to file initial documents, and then a gag order is placed often on everybody, and the defense has never responded. So the public is left with nothing but the unanswered allegations of the state. And it seems to me fair to have both. But then something worse happened for the defense. On December 21st, 2022, Rick's counsel, Andrew Baldwin, inadvertently emailed a summary log of the evidence on a flash drive received during discovery. The log did not contain any substantive evidence, but was similar to a table of contents. So now that makes the judge really mad, because you aren't supposed to mail out anything like this once the protective order is in place, and it got mailed out. Apparently there were people with a similar name, and he just hit this by accident. So now, the judge is not happy with the press release. The judge is now not happy with the inadvertent sending out of the information about the log of evidence, but they're quick to say this wasn't actually evidence. It was just it was a list of evidence. It wasn't the actual evidence itself. So that wasn't actually released. And I want to say thanks to Mike. I appreciate your watching, and I appreciate your support very much. Give me just a second. I am trying to okay. Sorry. Now, due to his declining mental and physical health, Rick asked to be moved out of maximum security segregation confinement. So this all relates to, we've talked about this on the channel before, but as he was in custody, Richard Allen's health began to decline. The picture I put on the thumbnail was a photograph that his attorneys took that showed just extreme deterioration inside custody. The defense claims part of the reason for that relates to the fact that he was assigned Odinist guards. When I first read that in one of their pleadings, I thought this is sort of unhinged. These lawyers are over the top. They have drunk the Kool-Aid. They have gone way too far into believing everything in this case. It turns out the state actually admitted it. The guards working there, a couple of them actually had Odinist patches on their uniforms. And so they weren't, apparently the defense wasn't kidding. But they asked first that Richard Allen be moved out of maximum security segregation confinement. Court said no. And counsel continued to file motions to change his confinement conditions. And that was one of the ones pending when the judge cracked down and they were asked to leave the case, more or less. Rick filed motions to suppress evidence, a motion in limine regarding the ballistics evidence, and a request for a hearing under Franks versus Delaware. Rick also signed a motion for speedy trial, which Rick's attorneys planned to file in early November to lock in the January trial date. During a telephone conference with the court in early October 2023, Rick's attorneys informed the court that they were ready to proceed to trial in January. And I want to say thank you very much to Victoria. Thanks for the super sticker. So all of these things are happening. What essentially the defense is saying is Rick Allen was a lot of trouble, and his attorneys were a lot of trouble. They were filing a bunch of things, not just a little bit. They were filing a lot of different things, and that was creating a lot of trouble, a lot of drama for the court. And I want to say thank you to Cutley too. Thank you. Yeah, happy Thanksgiving, everybody. I am excited about the holiday, and I have lots of videos to file during the holiday. So I'm not really taking a break, but it's a lot of fun. So hopefully you'll enjoy them too. So the trial court removed Rick's chosen counsel over his objections. So here comes our first peek into what happened. In August 2023, a former employee of Attorney Baldwin's office, Mitchell Westerman, stopped by Baldwin's office to visit. Westerman slipped into a conference room where he found crime scene photos and, by his own admission, secretly photographed some of the discovery material and disseminated it. Attorney Baldwin was not aware Westerman had done this. So this person, and now we know the M stands for Mitchell because they named him in this pleading. But the defense is very clear to say, we had no idea. I, the attorney, had no idea this was being done. He did this of his own accord, and he sent this out. And may I say too that having crime scene photographs out on the table in a conference room within your law office, as long as you normally lock the law office door, is probably not that serious a problem. I know that there was some question about that, but that strikes me as pretty normal from there. When counsel learned the material had been disseminated, they disclosed the matter in an email to the court and the state on October 6th. The prosecutor responded that he had known about the leak for a day and that the state was investigating the matter. So that was a pretty quick turnaround there. That this had very quickly he disclosed what had happened, told the court, okay, I just want you to know that we've actually been in, that we've looked at, that we know, strike all of that. All right, told the court, you know, we want you to know we know about this leak. We're disclosing it. We're not going to hide it. We're telling you up front that this happened and how it happened. So on October 9th, 2023, Westerman told Attorney Baldwin about his inappropriate, if not criminal, conduct in secretly photographing the discovery items. So the counsel, before they knew Westerman took it, disclosed that they had learned about the material having been disseminated, because they disclosed it to the state on October 6th, to the court and the state. And then on October 9, Baldwin finds out Westerman is the one who did it. So I'm a little bit unclear in that interplay right there. Rick's counsel informed the state and the court the following day. So I guess that would be October 10th. So he's telling them again. The parties had a telephone conference with the court that day to discuss the matter, and the state mentioned the issue of disqualifying counsel. A day later, counsel informed Richard Allen of the matter, and Richard Allen immediately and unequivocally indicated he still wanted his attorneys to represent him, believing their representation was in his best interest. And let me assure you, that is a really smart move on his part, because these lawyers are really invested. They care about this case and they've worked hard on this case. So absolutely 100%, yes, they should keep him there. After receiving Ritt's letter, the court notified the parties that it was scheduling a hearing on October 19th, 2023, to address other matters which have recently arisen, and ordered Ritt's counsel to cease work on Mr. Allen's case until we meet on the 19th. So what they're being told is that they are scheduling a hearing, but when the court told them, the moment the court told them to stop working on the case, cease working on the case until this hearing, really bad sign. They had to have been very concerned. And in fact, one of them showed up at the hearing with counsel, with a lawyer representing them. I think that was Baldwin. So that was a notice right there that there's a significant problem and the court is really unhappy. Stop working on the case, because that just never happens. And in fact, let me say, it not only so much never happens, courts won't even let you get off a case. If you have signed on to a case and trial is coming up, the court has to make a finding that the client won't be prejudiced if you try to get off the case. It's difficult. Courts don't want you to get off the case as the attorney, because it creates a huge problem for the client. They aren't ready for trial, or they have to try to find new counsel. So normally it's the other way around. The court trying to prevent the attorney from leaving the case, but not in this particular situation. And let me see what my number 11 was. So Baldwin says at this point, it looks like I forgot to highlight it, so sorry about that, but he says that the attorneys had the right to some notice about this. If they're going to be confronted with something this serious, they really had the right to some notice about this. And says on October 19th, 2023, the judge opened the courtroom to the media and for the first time authorized 1 or 2 cameras providing pool coverage to be permitted in the court session. This is really important. And in the end, I think that fact may be one of the things that sways the appellate court. That one fact right there, because I think it's really powerful. Up until then, the court was not allowing pool coverage, 1 or 2 cameras in the courtroom. But for this hearing, cameras. So we'll keep reading. During the conference, this is the conference before the hearing, the trial court read a prepared statement to Rick's counsel accusing them of gross negligence. These purported acts of gross negligence included the following. So the judge reads a statement saying, I believe you, the attorneys, have been grossly negligent, and here's how. Issued the press release, filed motions to protect his health and safety, which the court believed lacked evidentiary support. And may I say, I don't agree with that. The oldness patches alone put this in a different realm to me. Unintentionally emailing a discovery log, unspecified improper statements made in the motion to suppress, filing a tort claim notice to preserve Rick's right to seek redress for the conditions of his ongoing confinement. You have to file that notice early. Oh, darn it. Well, we'll hope it stops raining. Attorney Baldwin hiring a lawyer to appear on his behalf on the issue of sanctions or disqualification, and a third party impermissibly photographing discovery without the knowledge or consent of either lawyer. And they're saying none of this amounts to a reason to kit the attorneys off. That's what they're going to then argue. The court, but it gets really intense in this hearing. Really, really intense. And I want to say thank you very much to Squinting Cat, and I'm giving thanks too. So the court then informed Rick's attorneys that they had 2 options. Number 1, voluntarily withdraw their appearances, or 2, be disqualified as counsel after the court read its prepared statement in open court. And remember, the whole world is out there in the open court because there are cameras there. They are going to record this. They are going to tell the world exactly what the judge says in open court, and she's going to disqualify them anyway. She said, you can either do this right now and then I don't read this statement publicly, or I'm going to go out there, read this statement about how horrible you are in front of the television cameras, and then I'm going to throw you off the case anyway. Your choice. So Rick disagreed that they went out in the hall, apparently talked to their client. Rick disagreed that his trial counsel had engaged in any negligence, and he reaffirmed his desire for them to remain as his counsel, which, like I say, was a really good idea on his part. Counsel also informed the court that they believed their withdrawal was involuntary and done under duress, since their refusal to withdraw would publicly disparage their representation of the accused, framing their advocacy on his behalf as gross negligence, and cast Rick, his attorneys, and the merits of his defense in a negative light. So it's not just that it's going to be a problem for us, the attorneys. It's also going to make Richard Allen look bad, and it's going to make the whole defense look bad. His ability to defend himself is going to be harmed if we go out there in public court and you tell everybody how horrible we are. So at that point, I'm trying to make sure I start at the right spot. Such a public statement risked tainting the jury pool, harming their client's defense, undermining their professional relationship with the client, and possibly creating an actual conflict for their continued representation. So they are saying all of these statements would have been a real problem for Richard Allen. And I want to say thank you to Wendy for the super sticker. Rick, by counsel, also filed a motion seeking the special judge's recusal, Judge Gull. The trial court ordered the clerk to remove Rick's filings from the record because Attorney Rosie was no longer counsel of record. The court also appointed 2 public defenders to represent Rick. You're going to hear about that fact again in just a minute. The day before a hearing scheduled on October 31st, attorneys Baldwin and Rosie entered their appearances as Allen's retained counsel. So they entered their appearances anyway. In their appearances, Baldwin and Rosie reasserted their belief that they were improperly removed as counsel of record, and that they were now entering their appearance as private counsel in order to protect Allen's constitutional rights to a fair and speedy trial and to honor his 4th, 5th, and 6th Amendment rights. So they file anyway. You can see where this is just becoming total chaos by now. They try to file something and the judge says you can't, you're off the case. So they file appearances saying, we're going to come in and represent him. He wants us here. Just an absolute mess. The state indicated it agreed with the court that Ritt's counsel were grossly negligent. The state reiterated the examples of negligence the court had noted during the in-chambers hearing. This kind of reminded me of like mini-me. You know, the judge says one thing and mini-me, yeah, that's what I think too. So the state is jumping in on the court side, and the court acknowledged that Richard Allen wanted to hire Baldwin and Rosie, but said to Richard Allen, stated to him, I have grave concerns, Mr. Allen, about their representation of you. Sorry, I'm getting distracted in the chat. The previous findings by this court of their gross negligence. Mr. Allen, you are entitled to adequate representation in your case. You are entitled to a vigorous defense in your case. And this is difficult, Mr. Allen, because I know what you want. You've indicated that through your attorneys, but I cannot and will not allow these attorneys to represent you with the concerns that I've had, with the gross negligence that I have found. They withdrew. Rather than be found grossly negligent and be removed, I can't do it, sir. I just can't. I cannot allow that. Really, really strong words from the judge. And then, so the new attorneys are asked, okay, well, are you ready to go to trial? And they were like, oh, well, obviously nobody thought they would be ready in January. They said they couldn't even be sure they'd be ready next October. So a whole year from now, they weren't sure a year would be enough. And the brief goes on to say, look, the attorney-client relationship once established is inviolate. It shouldn't be severed. There shouldn't be subject to unwarranted interference. He wants us to represent him, and that should be allowed. Indiana recognizes only two. I'll make it a little clearer. There are only two ways where a trial court can say this attorney can't represent the client. One is if the lawyer isn't a member of the state bar. That's not the case here. Or the other is if the lawyer has an actual conflict of interest that's going to obstruct his ability to provide effective representation. No Indiana court has ever tolerated a trial judge removing a lawyer from a case over the client's objection based on the client's subjective belief. Based on the judge's subjective belief the lawyer is negligent or even grossly negligent. That's not one of the grounds right there, they're saying. Removal, if ever considered by a judge, should be an absolute last resort, and the removal proceedings should occur at a hearing where the defendant and his chosen counsel are provided notice and an opportunity to be heard. This court is and they're talking to the Supreme Court here. This court is the only court in the state that can order a speedy trial date. If it does not seize this opportunity now, it will forever be lost because the new counsel have already said they can't even do it within the next year. So there's no telling when he'll be tried, but for sure, the counsel is saying it's not going to be speedy. A new judge should also be appointed to avoid the appearance of bias that will otherwise permeate these proceedings. For many Hoosiers, this case marks the first time they have followed the workings of an Indiana court. And for those who aren't from the U.S., Hoosiers is a name used for people from Indiana. Yet for all rulings going forward, the public will question the judge's impartiality. Unbelievable. I mean, this is crazy stuff here. This is really, really wild stuff. But the battle is not even nearly over. Let me give you one example of how bitter this has been. And I've got a couple more, we've got several more things to talk to you about too. So I'm not ending. Nobody leave yet. So the defense counsel asked we'd like to get, Judge, a transcript. What they called the court reporter, and they said, oh, pull out just a little bit so you can see me a little better. They said, we'd like to get a transcript of that in-camera meeting we had with you before the public hearing on camera. That, by the way, is what you saw. What you saw was the public hearing on camera after that secret meeting behind closed doors. But they were told when the defense counsel, Rosie and Baldwin, asked for this, they were told, no, you can't have it. You're not in this case. You're not allowed to have the transcript, even though they were involved in that hearing. That, frankly, just shouldn't have happened. They had to file a motion to get the transcript. The Supreme Court granted that. The Supreme Court's like, yeah, we'd like to see that hearing. We'd like to see the transcript of that too. I mean, that was just an obvious one. That should have been clearly given to them. So that was, I think, a mistake on the part of the judge, or at least the court reporter, refusing to give it. So now what happens next is that the Indiana Public Defender Council weighs in. They weigh in the Supreme Court. You may be saying, well, okay, who is this? And let me say before I go any further, thank you very much, Wendy. I really appreciate the super sticker. Thank you. So at that point, a public defender, let me explain just in general. A public defender is an attorney who represents people accused of a crime who can't afford an attorney on their own. And the Public Defenders Council, which is a group of public defenders, filed an amicus brief. Depending on your part of the country, you may say amicus brief or amicus brief. Either way, what that is a friend of the court brief, and it's a brief that somebody files when they aren't a party to the case, but they believe they have an interest in the case and an opinion about the case, and they would like their opinion taken into account. It's almost always done in an appellate level. So they want their opinion taken into account on appeal. So the public defenders weigh in. We want you, Supreme Court, to know our opinion about this case. And it's pretty significant because it says a group agrees with you. And in this case, it's a group of people important within the bar, a group of people who represent a special group of people. It increases the chances that the judge is going to listen and going to rule with the defendant. The fact that someone has come in on their behalf and on their side. So that becomes important. So, and what they argued was that the history of having the public defenders is that the defense counsel needs to be independent from the judge. And if you have the judge appointing the defense counsel, remember I told you pay attention to that one statement in there. If you have the judge appointing, they're not independent. And so for that reason, the state has a county public defender board. And that board, not the judge, appoints the counsel. And that way there's separation. So the attorney isn't beholden to the judge and can fully and vigorously represent just the client without worrying about the judge. So I want to read just one paragraph from the brief that was written by the Public Defenders Council. Mr. Allen was pleased with the work of his initially appointed public defenders. Mr. Allen and the public that funds his defense should be entitled to more than vague and broad concerns about gross negligence and that a judge cannot and will not allow these attorneys to represent you. I can't do it, sir. I just can't. Such statements do not engender confidence in the criminal justice system for criminal defendants, many of whom believe that appointed counsel is not a real lawyer, but a public pretender or a lawyer who works for the state. When followed, the statutes and decisional law outlined above provide some means to dispel these misconceptions. When not followed, the trust and rapport developed during a full year of intensive representation is lost, and Mr. Allen is left to wait 9 additional months, incarcerated in the Department of Correction under conditions that he and his counsel of choice have stated undermine his ability to prepare his defense. So that is very strong. The defense is weighing in not just on the side of the attorneys and whether and to some extent anyway on the attorneys and the need for the client to be able to select the attorneys he wants to represent him, but even also saying in addition to that, even beyond that, this is not supposed to be the judge appointing, that this is supposed to be something that is where the defendants can be really confident that this person is not beholden to the judge, but really truly represents them. And judge or judges on the Supreme Court look at what's happening to Mr. Allen's right to a speedy trial. And that they're going to suggest is going to come back. That's going to come back on appeal because his counsel are going to say he didn't get the speedy trial he wanted and demanded because there were all these hijinks with the lawyers. When he had lawyers he was completely happy with. So that's what the public defender had to say when they came in. Now, we do know that Judge Gull is due to file a response on Monday. She stated in a motion for an extension, asked for an extension of 5 business days, and said that the Office of the Indiana Attorney General has declined to represent respondent in this matter, causing respondent to need to engage counsel. Now, that sounds really serious, like, whoa, they declined to represent her. What does that mean? Does that mean they were saying she really has no case at all? I don't think that's what's being said there. My guess is that the Indiana Attorney General was already representing the state and therefore couldn't really represent her individually, so she needed to get separate counsel. I would assume that the state or county is going to pay for that as well. So I don't think that means anything too significant. But interestingly, now normally a request for an extension of time is just routinely granted. Attorneys do that because if you don't grant the request for an extension of time by the other attorney, well, the next time you need an extension of time, guess what happens? They don't want to grant that for you. So attorneys just regularly do that. Oh, you need an extension? No problem. You need an extension? No problem. And it's a back and forth exchange. There are exceptions, of course, and this case is one of those exceptions because the relator, and I'll go ahead and make it a little bit bigger so you can read this, objected to Judge Gull having any additional time. And here's what was said, that Richard Allen, has been subjected to conditions that have led to him losing nearly half his body weight, which is amazing, and at times experiencing symptoms of psychosis. On one of those occasions, Attorney Rosie himself arranged for relator's move to the Cass County Jail, where the Cass County Sheriff agreed to accept relator. Yet, these repeated requests were denied. So he's saying, look, my conditions are horrible. My conditions are really horrible, so you don't need extra time. Moreover, relator was set to proceed to trial in January 2024 with a well-developed trial strategy and proffered defense. Yet, due to the actions of respondents, that trial date has been continued for at least 9 months. It's longer than that, October 24th, I think it was. Despite their heavy caseloads, counsel, we were able to do it. Counsel were able to file this action only 5 days later. Respondents currently have 7 days from the filing of the objection to respond. They're like, look, we're in worse shape than you are. Our client's rights are being trampled on. He's in incarceration, and we managed to do it in 5 days. So what's wrong with 7 for you? During counsel's preparation time, they were denied by respondents the ability to obtain one of the transcripts. And he goes into that discussion I told you about, the transcript relevant to this action, or even to listen to the audio recording from that proceeding. That was a big mistake. For the other transcripts, the court reporter for respondent refused to accept undersigned counsel's promise of payment by mail, even though they are officers of the court. The court reporter also refused to email electronic copies of the transcripts to counsel. This required counsel to physically drive to Allen County and back to obtain the transcripts. But I believe that in another document, they stated later that even though they went down there and even though they tried to get it, that they were told, no, you can't get it. I don't think I have that document for us tonight, but I'm pretty sure that's what happened. I'm pretty sure that I read that. And I want to say thank you, Magic Lady. I appreciate the super sticker. Thank you very much. So the extension, though, even though opposed by Richard Allen, was granted. And so Judge Gull has through November 27th to file her response. Let me go ahead and remove that. Now, this case, this is absolute insanity. And I'm talking about beyond Murdoch, beyond Lori Vallow Daybell. I'd still have to say this is about as crazy as I have ever seen. The response that we find out about on Monday should be absolutely fascinating. That's a really big day. Murdoch gets sentenced that day as well. There will be actual testimony from the victims of his financial crimes. And so that'll all be happening on Monday. Now, tomorrow, I hope to be dropping a video with some dramatic news in the Murdoch case about the son of Becky Hill. You may remember Becky Hill is the clerk of court accused of tampering with the jury. Now, her son has been arrested. That's all I'm going to tell you. You have to watch the video for tomorrow. And I'm trying to make sure. Oh, thank you, Bubba. I appreciate it. I don't want to leave anybody out. I really appreciate it. Thank y'all very much. I want to say thanks again to Marlon and Mike and Victoria and Cutley and Squinting Cat and Wendy and Magic Lady and Bubba. Thank you, everybody. So Thanksgiving, like I said, is an absolutely perfect time to say thank you to all of you for liking the videos, for subscribing, for coming and just following all of these cases with me, enjoying the legal aspects of it and talking about it. It means so much to me that you come. I have a great time. I love talking to y'all Monday, Wednesday, and Friday at 7. I also want to say a thank you to Marlon and mamapinks, who have been absolutely amazing and have just taken over the chat and helped so much. I'm very, very grateful to them. So happy Thanksgiving, everybody. And I look forward to seeing you on Friday, and look for another video, or maybe two, but probably only one tomorrow.